next session, and it's about the DGA, data markets. Tuesday night, there was an agreement reached on the DGA, and the idea is to boost the data economy in Europe, to create a framework to help and facilitate data sharing, especially with data intermediaries, and we want to talk about that today. We have here Damian Boeselager, who's a member of the European Parliament with Volt and the group of the Greens, and was involved and reached some, or helped to reach some changes in the last minute he can maybe talk about then. And Martin Semberger from Austria, from the Federal Ministry for Digital and Economic Affairs. He's head of the task force on open data and public sector information, which also is an important aspect of the DGA. And the German counterpart, somehow, Andreas Hartl from the ministry, head of division artificial intelligence and data economy and blockchain, and and from from Brussels or Luxembourg, representing the European Commission, Malte Beyer-Katzenberger with DG Connect. Welcome. So, the Commission and the EU wants to boost the data economy with this new instrument of data intermediaries. Maybe we can start a bit, and I would be interested, what is your general opinion about this tool, and do we have the right framework now with the DGA? So, you said we start with the Parliament, so Damian, maybe.
Makes sense to start with Malte, since he proposed, or the European Commission proposed this in the first place. But I can give just maybe a very quick answer to what you just asked, whether we have reached a good agreement. I think we have reached a good agreement that actually will help structure data markets. And I think for this we can relate a lot to the discussions that we also had yesterday, the whole question of what's the role of data intermediaries, and can we horizontally even regulate them or not. And I just want to maybe take a little step back and think about this question of data intermediaries, like why is there even a need to regulate that in the first place? And to look at that, I think it's important to understand that we had the consumer data revolution, where a couple of small companies basically won the race, and then there's a lot of talk about digital sovereignty in European digital sovereignty in Brussels, and now there's this obviously the revolution of industrial data happening at the same now as we speak. So a lot of companies are making the journey from being completely analog to being completely digital, and then maybe also have machine learning somewhere at the end of this process in their business models integrated. And in this journey, I think the question is still up for grabs of how do we what's our approach from a European level, how to structure that. Can we what will happen if we don't do anything, and so on. And then there are some people, mostly from France, who think that we should somehow make sure that the few companies that are winning this race should be French or European. But there's another side, and that is the question of not of digital sovereignty, but the question of digital competitiveness. And that's the one that I'm actually interested in. How can you make sure that the data markets that will develop or are developing as we speak when it comes to industrial data are functioning, and how can you make sure that they're not going to be just oligopolized again, potentially even by the same players that won the consumer data revolution, or I don't know, whatever you want to call it. And so I think there are a couple of steps to making sure that this doesn't happen. The first one is you have obviously a high concentration in the data storage market. Okay, cloud service provision is very concentrated. And these people are the most likely to potentially become data intermediaries, because they have already all the data stored, and some of them are already building data exchange platforms. So they could easily fulfill this role and then bundle their services and then basically force everyone and take the market power that they have in data storage into the data intermediation market. Once they have done that, they can obviously also take this power via the data intermediation market into the next market, which is all the services that will follow based on data. And this is a chain of oligopolistic power and market concentration that will almost automatically happen. And here, for me, the data intermediaries, to come back to the Data Governance Act, a crucial point where we can say, like, how can we make sure that data intermediation itself as a market is neutral, is open, has no barriers to entry, and is unbundled. And that's the key for me of this whole DGA, is commercially and also legally unbundled from other services provided within this digital framework. And so the key achievement, and then I also, let the others come in, but like for me of the Data Governance Act is that we managed to ensure neutral brokerage in the future data economy, which will then enable a lot of different, or hopefully enable a lot of different actors to become data intermediaries, data stock exchanges, if you want, and also hopefully a lot of startups and new businesses that then can buy this data or like get it for free, whatever the business model is of these data intermediaries, and build the very diverse European competitive landscape that we need.
Great. So yeah, Malte, maybe you can add your expectations on data markets and intermediaries under the new framework.
Yeah, let me first say good morning to you all, and thank you for allowing me to participate remotely. Interrupt me kindly if the sound or the quality is not good enough. I'm really happy about the agreement, and thank you to Damian and the entire team at the Parliament side, but also on the Council side, to Andreas, Martin, and all the delegations that helped us to shape this. I think we indeed propose a very innovative framework, especially on the Chapter 3 intermediaries. And I'll get to that maybe in a little moment, but let me also say that we have also innovative frameworks for the use of certain public sector that you cannot open up as open data. That's very known in statistical microdata access. The German audiences know the concept of Forschungsdatenzentrum, of which there are 38 in the country. And we want to really also roll out this approach that the algorithm, so to say, can come at some point to the data in the public sector as well. So we unleash the potential. And if you read the AI strategies of France and maybe UK from a few years back, that's also part of the contribution that the public sector unlocks registries, databases that contain valuable information. Then we also have data altruism, and we also hope that we have what we call Datenspende in German will take place. Here we also want to professionalize the organization of Datenspende, of data altruism, by focusing on organizations that can do this in a correct manner without over-regulating any instance of altruistic behavior, so that university centers can continue to collect data without being bothered by too much regulation. But if you want to be, so to say, the Red Cross for data altruism, you should be able to get a European label. Now, on the intermediaries, I think this is the really innovative part, and I can fully subscribe to what Damian has said in terms of the concepts. We think that it's really important to supplement the existing business model that we know from the personal data economy. I give you a service, you give me your data, and let me play with it, with an alternative model that at least supplements this first model, and in particular in the industrial value chains. And that's all to do with Gaia X, with Datenräume, data spaces, where we hear a lot of fear from industry that if they basically play it against the same playbook as we have seen it for the personal data economy, all the value of the digital data will go away. And it's correct that the traditional industries of Europe are not born digital, so they have a lot to catch up. And if we want to also look a bit at the lessons learned from the personal data economy, it's very important that we give them time to adapt. Otherwise, the monopolization trends in the digital economy will just aggravate anymore. And I think everyone around the globe recognizes that this is a tendency that we have to address. So we have Digital Markets Act for core platform services of what we can call gatekeepers. But I think data intermediation is such a crucial and such a distinct feature in the digital economy that we need to look at them almost as we look as banks at financial institutions in their neutrality as a neutral player, and that's really the message of Chapter 3. We want division of labor in the data economy. We want a little less bundling, a lot less bundling if you want, if you use a data intermediation service. So the economies of bundling and of scope, we feel for a traditional player like Volkswagen, Siemens have a bit gone too far. For Bosch, for all the industrial players, so they would never subscribe to that thing. Would the market be able to do this themselves? Possibly. With the neutrality rules of the DGA, we really want to make this, advance this call for neutral intermediation. And then maybe also already anticipating a question on the business model, I think here we also have to go to very basic economic models. I mean, money is still a good currency. We have learned in the data economy that data is the new currency, and we're looking at, oh, wonderful. But I think there's also some disconcern, not only on the consumer side, but also on the industrial side, that with the data, all the value and also the intelligence about what happens inside the factory, inside the firm goes away. So this is really what underpins the Chapter 3. But I'm very happy that we got to manage this in 1 year with a very dense schedule for everyone. National ministries had to really work hard on this, and also on the parliament side, there was a very intense work. So I spent half of my November in Brussels to get to the finalization, and really thankful for all players to support this.
Great. Andreas, are you happy as well? And so will we see a lot of new German companies are existing offering data exchanges and act as data intermediaries in the coming years?
Well, this is, of course, the huge promise we see and have. Let me first of all thank you for having me to this very distinguished panel. I would have loved to see maybe a female panelist too, but just on the side. Now, let me maybe just start with also a disclaimer. I'm currently representing an organization that is in a state of caretaking. We now know the draft for a coalition treaty, and this is why I see that also data, usage data is a huge issue when it comes to digital policy, but still I would like to have a little bit of legway to have an expert opinion, so please do not all that I will say on this panel as the official opinion of the sitting or the incoming federal government. That is very important to me. Now, let's start maybe with the data strategy of the European Commission. And the overall paramount goal was, we need more data. We need to unleash data. And the Data Governance Act was the first instrument, and it was supposed to create an enabling framework for data. And our understanding, and of course we had also some informal contacts when we were in the Council presidency in 2020, in the second semester, our understanding was that the Data Governance Act as an enabling framework should set flourishing guidelines and a framework that, creates trust, because trust was seen as the major obstacle. No, not having trust is the major obstacle for the development that we all like to see, for artificial intelligence, for fighting huge crises we have with climate change. At the moment, pandemic that wasn't foreseen when the DGA, the data strategy, was set up. Now, when we first read the Commission draft for the Data Governance Act, I had the impression that this is maybe more of a competition law, and I was looking for the aspects where really, data usage is supported. Because what happens is that what is currently allowed for under the primary law, under the treaties, now will be obliged to a license regime. Let's be clear. We will have for the intermediation services a prohibition with the preservation for a registration, and the authority that will monitor, they will of course check if the requirements according to Article 11 are abided with. So, you know, I started my career in the telecommunications arena, and we were fighting for the delicensing, for the opening up of the markets. Now maybe the political instrument is more to, you know, shut markets and look for entry doors. That's a political decision. I also would like to underline that we have to have in mind the interplay of the legal acts in place, in force, currently debated and coming up. And I think it's very often very interesting to see, and I heard that the discussion we just had on this panel was much like, we are in charge of data protection, privacy, competition affairs should not be a part of the objectives or instruments according to GDPR. I see that point, but to be very honest and frank, I think that this is a semi-permeable membrane, because privacy, for good reasons, is always prevailing according to the policymakers. And I don't see a discussion that GDPR can, of course, also be, for good reasons, maybe be just changed. If there's a need for change, that's on another discussion. But I think that is something we have to bear in mind. Then the Data Act will come up with complementary to regimes like the Digital Markets Act and the competition law we have in place, where significant market power and asymmetry of power is the necessary threshold for the regulatory instruments. We will have horizontal instruments. And the question is, what is the legitimation for these limitations to fundamental rights of researchers and companies? Not only I as a human being have fundamental rights according to the European Charter of Fundamental Rights, there's also this fundamental right for businesses, for enterprises, and for research. So, and this is a very difficult trade-off policymakers have to do. Now, I would, you know, just see that as a starting point for maybe what we will see in the upcoming discussion. So maybe to put it short, I think that we saw a shift in the objectives in the policy arena combined with the Data Governance Act.
Martin, yeah, what do you think about it, and what do we have to think about this first step?
Well, first of all, thanks a lot for the invitation. And yes, let me first and foremost say congratulations to the negotiators for this result. We, the member states, will, of course, first of all, have to scrutinize this, but hopefully this will all end up well, because it is, in our view, and I think this has been undoubtedly the opinion among member states, that there has not been a great kind of resistance to this act, actually, that we need some kind of governance act for data. I personally come from the corner of open data, and the Data Governance Act is actually an act that is complementing the Open Data Directive now at the European level. And as you mentioned, Andreas, quite controversially maybe also, I think that European legislation is going ever more from this kind of reactive path onto a proactive path. And instead of having regulation when something bad happens, well, then we have certain laws, but whatever happened, happened. And this is especially fatal in the sphere of data. So therefore, we need proactive regulation. And in this regard, for us as a smaller member state of the European Union, I would say, it is competition on the one hand, of course. We need to foster competition. We need to look at the smaller players, not only the big players. Damian, you mentioned, well, the kind of concentration we see in the data sphere. So, and the Data Governance Act adds exactly to this kind of, to this emptiness that we see. I think we all need a European approach, an own way we want to go. Therefore, we need to strengthen the laws in this regard that Europe wants to pursue. And the Data Governance Act essentially adds the notion of soft infrastructures. I mentioned the openness, so the government has to think not about closing down data, but on how to enable the reuse of data in kind of secure processing environments or for the purposes of data altruism altogether. And first and foremost, with regard to the private sector, I think, and to all of you when handling your personal data, the role of data intermediaries will be crucial in enabling, in kind of representing an enabling framework on the one hand, and also building the fundamental foundation for the emerging data spaces and data ecosystems. And I see that Europe here is going a different way than maybe other continents are doing it. And yes, we still don't know what the real implications will be of all of this. We see currently an abundance of legal acts, of course, so it is also difficult for us regulators, so to say, to know is it really good what we're doing, what are the intentions. But I think the intentions are good, and we're starting, I would say, with a lightweight approach, not too heavy regulation, and we need to carefully assess how these ecosystems will flourish and whether we're on the right path. Thanks a lot.
Yeah. Malte, so what are the chances in this ecosystem for new players? Or is there maybe a risk that as well the big ones, Amazon Web Services, Damian mentioned it, already is offering a data exchange, that they get now a framework, a legal framework, which provides trust and helps to get more companies using it that are still reluctant, and in the end we see the gatekeepers having a new business model added.
Let me say, I fully subscribe to what Martin said. We have to be really proactive in our intervention. That's probably also a lesson learned. If you have to remedy a rigidified market ex post, you have a lot of headwind and you have a lot of resistance. Now you show the market a bit the direction it wants to travel. For a very specific type of service, which we call data intermediation services, the rules are admittedly strict. The other model, that give me your data, Volkswagen, and I give you a service, continues to exist. So also industrial players are free to basically play this old model. Only when you are presenting yourself as a neutral middleman, as a neutral broker, if you want, then you are bound to do the rules. So it's the many-to-many data intermediation situations that we have. But the other model still exists, and if people are happy with that, it's fine as well. So are we confident that businesses will pick up? By the way, it's happening as we speak. I mean, there are a lot of startups in the personal data intermediation field, but also in the business-to-business intermediation field. And what we are first and foremost doing here is leveling the playing field, in the sense that any has the same chances to compete, and no one necessarily can benefit from vertical integration bundles anymore. That's, I think, an important amendment that came from Damian Boeselager's office. And on the Amazon Web Services and Microsoft, let's be very clear, according to what I understand to be their current business offering, is that they're offering you software tools to do it yourself. So the tools that Amazon Web Services have on offer and Microsoft are a turnkey software that you implement in your firm, but you basically intermediate on your own behalf. Amazon is not intermediating for you. But they could have gone there. They could have gone there without the Data Governance Act, and they can do so after, but not benefiting from the effects of scale and networks effects that they have, so that we also leave room for other startups. But let me also say one other thing. We're staring, I think, in the discussion very often at the 5 big techs, abbreviated commonly as GAFAM. But in many traditional industries, there are big players that are also can easily become or are already gatekeepers. And I mean, those who work on many industries know exactly what I'm talking about. So as we are transposing also the platform model into traditional industry sectors, we're risking to replicate the same kind of evolution towards big companies, and that can really disrupt also the industrial landscape of Europe, which is still a very SME-driven landscape. And that's not necessarily by size of member state. I mean, it's in every member state you have big and large players, but maybe in the large countries you have the larger players because the markets were always larger. But to be seen. So let's not only look at Amazon Web Services and others. There are many players, also European players, that could risk to become the gatekeepers in their respective ecosystems. And with the data spaces, Gaia X-driven or funded by the Commission or both, we really want this open ecosystem where the data sharing happens among peers and no player can exercise any power. And the kind of integrating organizer of the data space would be a regulated, well, with most of its facets, probably a regulated entity under Chapter 3. And that means we're ensuring peerness in these open industrial data ecosystem. I think that's really important for the data economy. And then the competition is not so much, can I amass data more than the other? It's that I have the original service that makes sense of the data. And I can really also pool in a completely different fashion among equals. I can pool my data among equals, but I keep the value of the data that I chipped into the pool. And it's not that the pool is administered by this third party who then skims off all the value. I think that's really the message of Chapter 3. Thank you.
How do you see the incentives for new players, for small companies, and also what could a business model be for them, and do we have the framework to support that?
So Johannes, who also helped me negotiate the act, and myself, we often joke that if we wouldn't work in the European Parliament, we would open a data stock exchange, because actually stock exchanges are highly profitable businesses, as we know. So if we believe that there is a market coming for this intermediary, basically, I think I would enter it instantly. So I think there are some questions of how can we explain how this market can be interesting, but I think players already understand that, and there are some ways via Digital Europe and other tools where you can try to incentivize setting up such a data stock exchange to a certain extent, but I think it will come. And I also don't believe that the regulation is extremely hard or strict or inhibiting, to be honest, because it doesn't forbid anyone from entering the market. It just says, and it doesn't even tell you if you have to do it for free or if you can take extremely high prices for the service that you're providing. It just says you can't use your market power from adjacent markets to bring people there and to somehow offer it for free so that the market would never come, because you can finance that with a 60% EBITDA margin of the cloud service provision. So I think that's, for me, why I believe that we actually ensured that the market could be created. And I very much agree also with Malte on saying, look at the DMA. We have been discussing this yesterday. We talk about a completely contorted market that we are trying to somehow remedy with ex post regulation. So does it really work that we always are 7 years too late, or can we potentially, I think you said this as well, can we somehow already learn from what we've seen before and just say, we're not stopping anyone from entering a market, or we're not stopping anyone from working with this, but let's try to pre-structure it. Not only because the data or the market for data intermediaries would be lost if we don't do that, but because this is such a key turn function for the future data economy, and it can be, and that would be bad to let it just fall down. I mean, if I talk to startups here in Berlin or also in Paris or in other cities that work on algorithms, so with algorithms, and have some form of machine learning programs or services that they want to offer, a key issue for them is access to data. And so we have to somehow set up these data markets so that it's not only, then also, as I said, in the later markets, that it's not only the big ones that can have the data and then analyze it and then offer the services and all the value add that will come from that, which will be a huge part, hopefully, of our European economy, but that this data is actually accessible for people to buy on markets. And for this, we need these intermediaries to be neutral and to be trusted. And then I think that would also answer the question of, if you're a business owner and you have the feeling that your data is being lost, if you share it, maybe competitors can take it and so on. I think there is a strong point in saying, if you know that the intermediary is neutral and you can always stop the licensing of the data that you have been doing with real-time data about your production processes or so on, if you can stop that anytime and you trust the intermediary to help you do that, I think there's a trust-building element in that as well. And just one comment on the sorry, but I'll make it very quick on the overall legislative structure. I think it's good to bring that in. I have long discussions with Axel Voss about GDPR and whether we should open it or not. I'm like, I sit with the Greens, but I'm not a Green Party member. I'm not ideological about most things, maybe about Europe being a European democracy, but like that's another thing. But like, I think we can have discussions on whether and how that there are issues in GDPR, and we had them yesterday, and we can. I mean, I'm happy to have these discussions. I'm not an expert on it, to be quite frank, but I think overall, to bring these points into other acts, like the Data Governance Act has been tried many times, or to bring them into the Data Act, and it's just mixing up things that should not, you shouldn't try to solve problems elsewhere. I think we should be very clear, and I think the setup is not so bad. GDPR does all the personal data stuff, and the DGA, at least Chapter 3, somehow structures the market for data intermediaries, and the Data Act will maybe talk about some things that we already saw in the impact assessments about, co-created data sets and how can we somehow support that. So I think overall the setup is not so bad, Malte.
Yeah, but yesterday in the discussion when it comes to personal data and personal data management services, the PIMs that could help me as a user with my rights I have under the GDPR. Luisa Specht and Professor Kerber said the problem is that she misses an obligation for the gatekeepers then to comply with the instructions the PIMs are giving them, and then that's something, because of the consent in GDPR, which lacks. How do you see that? And can PIMs for personal data really act now and are helpful with the framework we have?
Thank you. First of all, Damian, it's really good to see that there's not so much GDPR fatigue anymore in the European Parliament. And I would really like to see that, as in the Artificial Intelligence Act, where specific provisions are proposed from the Commission, to have specific allowances for processing data. Maybe that could be something also for the data regime. Because I think I'm not a real expert, so I would not never fuss with people who are really deep experts. But what I understood and what we discussed internally when it comes to the Data Governance Act and data intermediaries and data trusters, this aspect of general consent. And there is no consent if general consent is possible. And maybe a clarification in a legislative act would help. That a service provider who helps me as a data subject in executing my rights, my right of data self-determination. I would love to have that. And maybe if we could have this clarification that I can generally consent, give general consent to a PIMS, and he with a much larger market or negotiating power than I could have as an individual can really execute the rights I have. I think that's a nice idea, and I would love to see that discussion.
Maybe quickly jump in. I mean, I think the also came in late. I think the panels before probably would have been much more, valid in discussing this. But I mean, I just know that even though I might not be in the details as you are, I know that broad consent in general is not really something that the Green Group will ever be, accepting. So I think even there, if I would be negotiating this, there would also be my hands would be bound.
Okay, thought there was no fatigue. No, but maybe coming back to the DGA, and I would like to, not that you get me wrong. I really hope that the promise of the Data Governance Act will realize. I really do. The thing I just see is that, you know, it was for us at least. Maybe you had better access than we had. It was very hard for us to find existing businesses that would fall under the scope of Chapter 3. In most cases, the main objective, or now what it's called aims to, the main purpose of companies is data analytics, but not orchestrating data sharing as a main objective, as a main service of a service provider. So to be very simplifying for the sake of the discussion, we are talking about a market of data intermediaries which is really hard to examine because I don't see so many companies. And this is, you know, because we now have a new instrument of this data intermediation service providers, and I really hope that there will be investors, as you maybe would have been. But I don't know. You know, we discussed this a lot internally, and it was very controversial within the federal government. But the main point was, you know, on one side it was not enough. On the other side, it was too much. It is really a hard trade-off.
So
and
in the middle, we were good.
yeah, I hope so. I really hope so. But you know, the thing is, we don't know. I don't want to say experimental. It's you know, trying to set the ground for a promise of having globally significant data intermediation service providers. We try that with Gaia-X, and we really hope that this will support initiatives as Gaia-X, and especially Gaia-X. But still, I don't know if there will be companies that will voluntarily, what they could do until now do under the requirements of Article 11. I don't know. Again, I hope this will happen, but we don't know. And what I would like to see also is a bit of an open-mindedness to maybe in 2 or 3 years, when nothing happens, we could evaluate this, and also the interplay with all the policy objectives we have, and then to be open-minded for a reassessment of what are the best instruments for the undisputed, for the, you know, we have a so broad consensus when it comes to the objectives, but we have huge discussions on the instruments and what are the specific objectives of what legislative act, and that's the point. But again, I don't see the incentive for investors at the moment, and especially not with the DGA. And I don't know if trust is a huge reason or obstacle, but I don't think it's the sole obstacle. For instance, maybe just another sentence, Oliver. Maybe one of the hurdles that we don't see a market for data sharing, if it's about intermediaries or not. And by the way, the intermediation is one of the streams I see. Also being in charge of blockchain, I see also the stream of disintermediation, like Ocean Protocol, for instance, who also try to facilitate a marketplace for data sharing the other way around. Not have an intermediary, but to have a protocol that in a way serves as an intermediary. But what I wanted to come back to is, I think that when it comes to incentives for data holders, I'm not talking about data subjects because that is a special discussion, but especially when it comes to IoT data, B2B data, what is the incentive for an SME to share data? I think it would really help just one. Right. Yeah. So, and you know, sometimes when they say we need a market price tag, I don't mean that, you know, individuals should sell their data. That's not the point. But for a business, it could be helpful if we would have some kind of principles or maybe even a regulation, legislation on to what extent data can be a non-tangible asset in the balance sheet of a company. We are currently having a project, Future Data Assets, where we examine this. Our colleagues in Japan having a similar project at the moment. They see the same problem with this price tag incentive problem.
Can I raise my hand as well? I'm a bit in the outside, but after Martin, maybe.
Yeah, sure.
May I?
Martin,
quite a lot has been
and
said.
afterwards, if you have question, of course, we open.
I would kind of try to summarize it in this kind of way that you either have the classical perspective or a new perspective that is emerging here. The classical view is, and we have kind of data stores, data analytics happening in a silo, and the big players in the data economy are those players who agglomerate data and use it for their own purposes. But people more and more distrust this form of data economy, this monopolization, and this is the way why we regulate. And the other vision here we want to kind of perpetuate is a decentralized ecosystem that links all those smaller players and forms trust among them. I think trust is a key question in this, but not only. And I would say, I would interpret the DGA in a quite pragmatic way. A lot will depend upon the actors themselves, especially the data intermediaries, on what they will do. Andreas, you mentioned there are no companies on the market. I wouldn't say there are no companies there, but if you look at the global scene, where are those data intermediaries emerging? It is in Europe. Thus, it is a European idea, and maybe we can build upon this to create a ecosystem that is more alike with the roots of the internet than we see it today. This kind of network thinking, the decentralized thinking, and the collaboration thinking. And well, yeah, it's going to be difficult, but I think, and I think Audrey Tang, the minister from Taiwan, also mentioned it. Many things, many pragmatic solutions cannot be done by regulation, but will build upon the services of the data intermediaries, either on the basis of the GDPR, or facilitating data sharing. We're talking now about business-to-business sharing, business-to-government sharing, business-to-consumer sharing, all these kind of aspects. Because in this regard, you need this special link, because else you will always have only monopolies. And I think you also mentioned kind of the gatekeeper role, or it was discussed yesterday. Yes, indeed, I do see personally kind of a big chance to kind of also and Malte mentioned it, actually, the classical models will persist. They can still, there is no, well, it can happen. There is no limits to that. But we're pursuing a more liberal approach here, and I think the role of the gatekeepers might shift ever more to other kind of gatekeepers, or at least to say, giving back control to the users is key. Thus, I, as a data subject, can more easily control my own data. We're talking about data is unavailable at the moment, or if it's available, it's only available for the big players. Thus, we need to work on this. And I guess if we do it right, and if the data intermediaries really build upon the foundation of the strong GDPR and these acts, then we can contribute to a flourishing data economy wherein people and companies trust those neutral intermediaries and establish the necessary links also to the big players. And then let the markets decide on which services will prevail in the end. It's a market economy, and I guess that, well, those users that are aware of this will more and more shift rather to these data intermediaries. That's at least the big hope in it.
Yeah, Malte, you wanted to add?
Yeah, there's so many fascinating aspects. I will be quite brief. One of the selling points of a company like Darbex was, if you trade through me, I'm the notary. I confirm that you traded your data for value X, and then you can add it to your balance sheet. That's a function. So fully with Andreas that we need that, and that is one of the services that actually implicit the data intermediation service can offer. Now, on the question, do we see enough companies? I think that has to do with the sexiness of the market, and I am perfectly happy that the DGA as well as the intermediation services are not as sexy as the big techs that we're all constantly mentioning in our conversations. If these are discrete companies in the background, it's perfectly acceptable for me. And we see them here and there and everywhere. We see them in farming ecosystems. I mean, that farmers bracket SMEs, end of bracket, could independently of the tech providers that sell them farming equipment, pool data among themselves to further improve the operations of the farm. Maybe form a farming data union if you want. I mean, that's the great innovation that we're bringing with the DGA. We're having the legal framework for that, and it will happen. SMEs want to also benchmark themselves for operations optimization and things like that. That's when they want to share their data, and the intermediaries will make it happen without the farmer feeling being ripped off because they are small players that cannot master this. So in the automotive, the neutral intermediary is an integral part of the competitive discussion around who accesses in-vehicle data. So there's a critical function that intermediaries could play. There's tons of technical reasons that I can't discuss here today why certain things don't happen, but we have them on the market. They're called Autonomo, they're called HERE, they're called Caruso. These intermediaries actually exist because here the aftermarket specifically wants a neutral intermediary. But that's a separate conversation of a very nice panel. Now, final point on the PIMs. And I have high esteem for Luisa and for Wolfgang on this, and we regularly converse. But we're hitting, well, we will continue to hit a certain limitation under the GDPR, and Damian alluded already to it. But it's not only in the Green Group of the European Parliament that people are very skeptical about not only broad consent, but also about exercising on behalf. And we discussed this with the supervisory authorities in the Data Protection Board. We discussed it with our internal colleagues, and people are quite careful to make a bit more flexibility on both fronts. And I fully regret it. I'm fully with Andreas that we need to go there, and with Luisa and Wolfgang. But under the current GDPR enforcement situation, we will not get there. So, and that also applies to the obligation to use an intermediary. I mean, that's really difficult. So some more headwind to go. I wish we could flexibilize. I'm also calling on the supervisory authorities that may listen to this and are here in the room to really consider this. The French CNIL has made a small step. The right to data access and to data portability can be exercised by a third party. That's a first step for the benefit of a player like Cozy Cloud. And if you have that, actually these services make sense. But they will also make sense, the PIM services make sense because our lives will get more digital. And we need services that wrap around our life, that integrate the data from all the different places that they currently are. We're digitizing banking, we're digitizing our travel, our mobility cards, but we're digitizing this in the silos that we're presented with as consumers. And this will not go on for very long. People will want a personal data cloud to have everything in one account, in one cloud, and not in 15 or 25 or 55. I think Martin Schall from the Competition Law Commission 4.0 mentioned 256 user accounts in a previous panel on this same stage. That's probably for a geeky professional a high number, but all of us will have these 255 user accounts, and it's completely untenable that we manage them with 255 different logins and passwords.
Okay, you wanted to add something? Or?
Yeah, maybe to Malte, thank you very much that at least you we have broad consent in many aspects we discuss here. I just wanted to take up one idea from the discussion, and I would like to make the point that with the adequacy we see for international data flows for GDPR, and now we also have a stipulation in the Data Governance Act. I see the point, I see the reasoning, but representing a ministry that is also in charge of trade, I just want to make the point that we have to be really careful that we as the European Union do not enter in something that others could see as unilateral steps to make provisions when it comes to data, and data is global. We see that in the current G7 presidency of the United Kingdom and Japan, G20, free flow of data with trust. just saying that, you know, with this approach of we set the rules, we are the regulator, and others have to abide. We have to see this international trade aspect too. We are, as European Union, highly competent, and we have a high welfare with multilateralism. So my point would be that we do not see this, that we have to bear in mind this multilateralism aspect also when it comes to data policy. That would be just something I wanted to also make on this panel today. Thank you.
Great.
If I can just, sorry, I have to come in here because there's a lot of confusion that we also hear in stakeholder. The adequacy decisions that we talk about pertain to data in public registries that are coming there because the law forces companies and consumers to give the data to the public registry. They have no choice. And where now there's a question whether to reuse them outside the union. And best regards to your trade colleagues if they listen here today, I think regulating how we use public sector registry data is perfect because other countries, big countries, take very unilateral decisions as well. So let's be clear what we're talking about. We're talking about the transfer in very, very limited circumstances of data forced give by companies into public registries.
Malte, thank you. I don't want to be misunderstood. You're perfectly right with your argument on Chapter 2 and Article 30, I think it is, on the international flows when it comes to public sector informational data. That's right. I just want to make a general comment because this international aspect, international data flows, at least is worrying us that I think Francesca Bria, who will also be there today, I have a quote of her in my mind, which goes like maybe I don't remember it word by word, but in essence it was: does Europe want to be significant or relevant as a regulator or as an innovator? There must be a trade-off. Please, both, but not only one aspect of that.
If I might just chip quickly, I think we can see it as two sides of a coin. We have been talking a lot about data protection, that's one side of the coin, and here exactly in the Data Governance Act and in the upcoming Data Act, it's the other side of the coin. Actually, we're talking about how to grant access to others or to transfer data abroad. So therefore, we are actually talking about opening up channels, being multilateral. And as you mentioned, Andreas, correctly, I think the innovation is key, and the right path for Europe is to develop new innovative solutions. And I think that in this regard, Europe can be regarded as a startup nation, kind of. It's a new idea, and we're trying to push forward with these data intermediaries, so that others can grasp this up. There is no limit that it's only possible in Europe, but it's enhancing intra-European data flows and also maybe, or we have to see, global data flows as well. But of course, we in Europe, we will further develop European data spaces in which certain conditions will prevail. Yeah.
Yeah, I don't know if there are any questions outside, but maybe just to quickly react, I also believe that when we talk about data flows, and you said we have a multilateral system, the bigger issue is, for me, at least from my perspective of the Industrial Policy Committee, for the data flow within Europe that you also just mentioned. Because obviously if you talk to, as I said again, an algorithm-based startup here in Berlin, then they say, look, we always hit national borders when we try to scale when it comes to data usage. So we have to open up another company, we have to somehow understand the national regulation. There's a lot of legal cost that comes up for understanding how you can use the data that is there and so on. So in general, I think it makes sense to look at this from a European level, and also, as Malte also said, I mean, I think the high sensitive public registry data that we're talking about is somehow like a very special case. Yeah.
Do you have questions here in the room? Pinto?
If I may.
Yeah.
Thinking one concrete question, maybe to Damian or to Malte. Thinking of Article 11.1 and the neutrality, how it responds or how it relates to the incentives. What's your comment? Or
I mean, as I said, for me, the neutrality was like the core point, and actually brings me back to the question of regulation or innovation that was mentioned. I think we try to regulate to allow for innovation. That's basically exactly what this DGA and Article 11 is about. What this chapter is about is to try to say we don't just, I mean, I said it before, so like we don't just say like if you're already big and you have a lot of data already that you're somehow maintaining or controlling or whatever it is for others as a cloud service provider, you just enter the next market and it's yours, but you actually say, look, the incentives of like going in there and trying to actually compete and maybe even compete with a price will be given because the market is not just flooded with a zero price somehow offering, yeah? So where you don't have any chance to make any profit because it's just for free. So I think that's for us one of the core elements, and it also brings me back to the question of why do people not share data because they don't get money for it. Yeah, I mean, you said we are in a market economy, but the market often doesn't exist yet. And I think the only thing that this DGA is trying to do is to actually help build that market so that you can share your data and see what kind of money you get. You know, like, I mean, let's see, because obviously the issue is that when you share it, you have the fear that maybe a competitor will use it, but you also don't know what the potential upside will be because nobody knows yet what value this data could bring if it's analyzed correctly by some form of a use case. So the only thing that we somehow need to ensure is that this data is somewhere lying around on a data exchange, sitting there waiting for someone to say, hey, I actually think that, you know, sensor data of laundry machines is super interesting to do something with it, you know, so maybe I'll just buy that or license that for like a couple of weeks in real-time flows and see if I can pair it with weather data to understand if my laundry, you know, is drying better or whatever, if it's raining, I don't know. But like I think to have all this innovation come forward, and I'm super excited to see it for all these, I don't know, verschränken you would say in German, like for all this data to be combined and analyzed and new services to be built of it. But for that, it needs to lie around somewhere, and for that, businesses need to have an incentive to put it somewhere where they believe it's trusted, that, you know, that the metadata that, I think most of the time just metadata that's lying around there will not be abused, and that they can then, when somebody asks them to buy it, still assess whether they want to sell it or license it out for a certain time. So I think the incentives are there. I think Article 11 is exactly why they are there.
Could I also kind of touch upon what Pencho has said? I think it is such a crucial provision in the Act itself. I would consider us as kind of, we are constructors of living organisms, and the data intermediaries will be the blood veins in the data economy. Or if you compare it with the highways for now, one could argue the highway belongs to one certain company that is regulating traffic on this highway, but do we want this? Do we want everything to happen in this ecosystem controlled by this player? No, I think the way is we're talking here about the necessary soft infrastructures that everybody can use, that are fair, that are accessible to everyone, and where everybody can trust in their usage actually. And we need to foster this development of this highway network that we once started physically 100 years ago in a physical world, and now we're trying to do the same things kind of in a digital sphere. And just imagine, consent management is hampering further developments. It's not really user friendly. So data intermediaries have a great potential in contributing to consent management. We've been hearing about encryption of data of data lines, so to say. We're talking about so many aspects where we will actually need data intermediaries for the data ecosystems, for the emergence of the Gaia X ecosystems, so that it is such a crucial step to have, and also to be complemented by further legislation that is upcoming.
Yeah, upcoming is the Data Act next year, and I think next year when we sit here we will talk about that, but maybe as the last point, we have 10 minutes left. What, in your opinion, are the important things we need in the Data Act to complement the DGA and to really create this system you described with the blood veins and the flourishing data ecosystem?
Was that a question to me?
To all, but yeah, if you want to start. Or Malte, you wanted to?
No, I want to take notes actually, because it may matter for our drafting.
But I
Okay,
do have
then.
an idea, and I think
Yes.
we've been, this morning, we've been talking about data for the public interest. And I do expect that something is upcoming in this Data Act that in handling the pandemic or in handling kind of the grand challenges of our societies, we need data for the public interest on the one hand, and I do want to see interoperability aspects addressed also in the Data Act with regard to business sharing, business to government sharing, and all these kind of aspects. So there are still some legal uncertainties. Yes, those are the first and foremost the first expectations we have. Yeah.
So I think the Data Act is also the reason why I came to this conference, because I mean all the discussions that we're having, I think somehow can flow into that, and so for me it's really an education. I'm not a competition lawyer. I'm also not a privacy lawyer, and I think it's interesting for me to sit here. So thanks a lot for organizing this. All this is very insightful. But in my view, once we have now created the marketplace, the question is what else is inhibiting companies from sharing data on these marketplaces? And one of the core questions is how do you deal with co-created data sets? So, and it can be data, like it can be a person that somehow has their mobile phone or is driving the self-driving car, but it can also obviously be a company on the user side that bought a machine, a steel cutting machine or something, and then uses the steel cutting machine, and the question is, are they allowed to somehow monetize the data that they're producing by cutting steel, or is it the person who actually sold them the steel cutting machine and put the sensors in and the software in and actually has the data to maintain? So, and both probably have some form of a right, and the question is, beyond the rights that they have to use the data for their daily work, who is allowed to share that? And just to give you one example, I don't even know where I heard it, to be honest, but I love it so much that I have to share it, is the whole question of, I talked about it earlier, the laundry machine. So if you have a laundry machine and you buy that and then you use it, and then it's connected to the internet as a part of the Internet of Things, and that is cool for you because you can potentially see on your app whether your laundry machine is still running or you started, so that you can put as whatever you want to do with that. And for whoever produced the laundry machine, it's cool because they can see how it's running and can potentially improve their production or worsen it because they want to sell it more often. I don't know, whatever. So, but the interesting thing is that what I was told is that maybe, I don't know, Malte, if it was in your context that we discussed this, but that below the laundry drum there is a sensor which is very sensible to seismographic movement. So, which means that there's data being produced that if you think about it, if you have laundry machines everywhere across the world, you have a super interesting seismographic network to basically, either be early warnings for earthquakes or somehow give you some research data. So, but who is allowed to share this data or sell it potentially even on a data stock exchange? I think that's a key question for me that I want to understand, if we can solve that horizontally in the Data Act.
So Malte, will the Data Act create a network of earthquake warning systems of the laundry from Damian and all of us, or what other things we have to expect and what is needed?
Well, I think the interesting thing about the example, which indeed I whispered into Damian's ear, is because someone else whispered it into my ear from a manufacturer, is that you have so much reuse potential of the data, and the key call is to not lock the data up with exclusive rights, but with additional rights that can be exercised in parallel, which obviously brings the question, sometimes you have conflicting interests in the data. Sometimes there is a trade secret that is at risk with the data. It's personal privacy that stands in the way. Thinking about a connected car shared by a household, shared by a rental company, by a car sharing. I mean, there are differences, scenarios where you need to be sure that you also manage the conflicts in the rights. But I think the key ambition of the Data Act will be to look at IoT data because of these co-created or co-generated data. And in farming, this is a huge question, debate. And in many industrial contexts, it's really an emerging discussion. Obviously, many companies will tell you, and the business associations present here will tell you, well, contracts can manage all that. But I think we need some clarity on the usage of these rights. And then, yes, we want to work on the government better benefiting from data. And as you know from the inception investment, we also look at cloud switchability, which again in the Gaia-X context, I think plays an important role. But yeah, I'm listening also here to just see whether we are capturing the right cases. And yeah, I'm looking forward to the next session in December 2022 to discuss then the Data Act progress.
Andreas.
Thank you. So first of all, I think that interoperability is key. And what it would be very important for us is that we would have this smooth interplay of the legislation and Gaia-X. So maybe it could be that whatever is being created amongst industry actors in the Gaia-X community would be supported by the legislation we see in the Data Act. So that would be something we would of course find very attractive. Now maybe 2 remarks on business to business or data sharing in general. We all know that data is a non-rival good. We are not talking about scarcity. Once we have data, it can be copied for low costs, and so the issue I would see is that we do not create exclusive rights, as Malte put it, so that we are not talking about ownership, but who is allowed to use data. I mean, we don't have to clarify who's the owner. We have to clarify who can use it. And I think then it comes to, maybe it would be very spectacular to have a principle, an open data principle with the exemptions we all know. Privacy, business or trade secrets. And I really don't know in what direction this will go, but this is at least the vision I have. Why should companies refrain to share their data? We were talking about this incentive price tag issue, but I mean, if your primary use is fulfilled, why not share it? Because reciprocally, you have the promise that you can use data from others too. And I think this is something I'm really looking forward to. Malte, and talking about trust, I have a huge trust in the colleagues from the European Commission in Brussels, and especially in Luxembourg. And maybe a last comment on business to government. I'm a bit skeptical there. I would say that we need sector-specific regulation, which company should share data for specific reasons with governments. But I'm really skeptic to see horizontal stipulations on that. I think this has to be decided very case by case, on a case-by-case basis. But of course, at the end of the day, I would like to see that also that data would be shared with public administrations too.
If I may.
One quick, but yeah, we have to continue. And
Malte, Damian, and
super quick.
Martin.
I think we should be very careful translating anything that Gaia-X develops into legislation, because I mean, then we have to look at what's the governance of Gaia-X, who is represented, how does it work. I mean, we can discuss what kind of need exists in the European market and how regulation can somehow work with that and see what the existing initiatives are. One of them being Gaia-X, but I think that is a super quick clarification.
There is a junction between legislation and standards and norms, which is for centuries very efficient and successful. This is all I'm saying, that standards should be left to industry, but of course on the basis of state-set legislation. I was just talking about this conjunction between both, and that at least the legislation should not contradict, or, you know, of course, if there would be great reasons. I mean, I'm supporting lawmakers too, and legislators. But we should really see that we're creating currently something significant in Europe with Gaia-X on the innovation side. But of course, I also see the other side of the coin, the regulatory side. Again, interplay, the junction.
We talk about Gaia X later in the summit. So yeah, one final really short remark.
I think we can see that we're all constructors, either legal constructors or down there in the physical or virtual worlds. Let me just be brief about this. I do see great potential for managing pandemic situations and so on, that the government needs data and needs it quickly to react. And so I would be fully with the digital minister of Taiwan in this regard. Let us work with the companies and with the people, and let us build upon this trust in order to create future data spaces. Yeah.
Great. Malte?
I don't want to really add on substance. I think it was a great panel. Just to advertise that my colleague Anna Ludin is in the room. If you want to approach her in the breaks and whisper into her ear what you think should be in the Data Act or should not be in the Data Act, she's part of our great team here in Luxembourg. So thank you for having hosted me virtually, and good success for the conference. I really wish to be there with you, but COVID is making things really complicated.
Great, yeah. So
My team, so I'm happy to share Anna now with the Commission.
But where is Anna? She was here. Okay. Okay.
yeah,
Thank you very much. Thank you, Malte. And we keep your promise seriously that you are going to visit us next year in Berlin and discuss the Data Act and all the other subjects around. It was a great discussion. Many thanks to you.